Okay, so let me. I'm just still trying to make sure. It's about 4:20 on a Wednesday afternoon. Really nice and cool outside in the shade. Taking my dog for a walk, and I'm talking to you about this subject of business law and business ethics as part of MBA 530. I realized that this should have been a little earlier now. I just kind of thought that, like every when it said Monday, May 20th, I thought it was Monday, May 20th. Unfortunately, for both of us, I know, of course, that it's supposed to be available. There's some exercise you need to do by May 20th. My apologies for that, but I'm new to this technology, for at least I claim to be new to this technology. I'm here, and I live next door, so for me, it's kind of like I don't understand why I'm not in the classroom. But you're looking at a view down the second road, and I really can't do much with the lens on this iPhone that I'm using. But at the end of the shot, there at the end of the second road, is the Mystical Rose Oratory. So I am here on campus, and I am walking my dog. Well, actually, I'm next door to campus. I live, like I said, in the building complex next to Chaminade at the base of the hill. But the park goes all the way up to the third road. It does going back up quite some ways. More than you need to know, but hey, I get to do this, or I'm supposed to do this, so you get to listen to what it is that I want to say. Anyway, so my name is Wayne Connor. I teach accounting. I teach primarily the tax courses. I teach the ethics courses at the undergraduate level in many different disciplines, including science and math and business, as well as communications. I do also teach upper division, or I guess graduate courses in school education and business and I guess criminology, criminal justice. I am a licensed attorney, and I still have an active license to practice. I think I'm the only one on the campus that has one, and I think that's what accounts for my great popularity, is the fact that people always come to see me when they have problems. The problem, of course, is that even though I am licensed and I am active, I just went to court this past Monday, and but it's a very specialized type of practice. I do tax and business. So when people come to me with the kinds of problems that most people experience, whether they be along the lines of debtor creditor, bankruptcy, abuse, I'm not necessarily well suited to be or to help them in those things. But so this is the intro part. I abhor teaching to the test, so I'm going to talk to you a little bit in general about this, and I'm going to do it in the old school fashion where I talk and you listen, which really means that if you're going to get anything out of this, it's going to be that you have to take notes. So I'm going to start with this, and this is the basic premise of law. Law is basically a system of rules, regulations, administrative procedures, and other ways that we as a society communicate and also implement the ideas of what can be and what can't be done. So when we talk about civil law, which we will be doing exclusively in business law, and then things related to business in the MBA program, we're going to be talking about the things that you have a right to do. You have a right to make a contract. You have a right to have that contract respected. You have a right to get money in the event that that contract is not respected if if it works from that fashion. What you will not have a right to do is put somebody in jail. So that's why that's the realm of criminal law. And that is very rarely, if ever, seen in business. Now, of course, from a societal and ethical perspective, perhaps there should be a way in which people can be put into jail for business violations, but we hardly see CEOs being handcuffed and led to jail. And remember the Great Recession, 2007, 8, 9. You didn't see one single one of those American CEO banksters get arrested, nor did any of them get put on trial. And definitely none of them went to jail. There was one person, of course, in the UK, but he wasn't even at a high level. I mean, he made a lot of money, he scammed a lot of money, but he didn't have anything that was so serious that society said you're going to lose your liberty or possibly even your life for doing this. And then there are ways and there are reasons for that, because if you think about how things developed in the United States as far as our system of law is concerned, particularly on the business side, we know that we escaped, or not escaped, but the Pilgrims came to the United States for religious freedom, but also because in England, if you found yourself to be in debt and you could not pay your debt back, you would go to debtor's prison. In other words, you would go to jail. This is something that the founding fathers in the United States definitely did not want to have happen. So as far as the rules are concerned, as far as bankruptcy is concerned, we know that for the most part, nobody goes to jail. So that's one of the things that we know, that it just involves certain rights as to property. So again, law. I'm going to talk about law first. And law, in my mind, and the way that's been communicated over the years, has three elements. There is a right, a duty, and a capacity. Again, the three elements are right, duty, and capacity. I just flipped the screen, so it might have just done something funny. But a right is a special feature or privilege. A special feature or privilege held by an individual or by society as a whole. A right is a special feature or privilege held by an individual or society as a whole. A duty is a special obligation. It is a special obligation which is recognized, a special obligation that is recognized as being owed to the individual or to society. And finally, the third element is what we call capacity. Capacity is the power to use the legal system. Capacity is the power to use the legal system to enforce the right. Now, as far as the definition of law is concerned, and the three elements, right, duty, and capacity, it's what we refer to as a conjunctive definition. In other words, all three parts have to be there. All three elements must be present. And we do not have law in the event that only two of the three, or one of the three, or none of the three are there. So all three must be present. So in proving something as a matter of law, you have to prove that all three things are there: right, duty, and capacity. Now, the way in which we do this type of legal analysis is abbreviated as IRAC, or IRAC. In IRAC, the I stands for the issue or the problem that's being looked upon by the law. The R is the actual rule of law. What is the violation concerning, or what is the right pertaining to? Then we look at the A, which is the application or the analysis. So what we try to do is, or not try, what we do is we apply the rules in context of what happened. So we find out what the scenario was, what the facts were, and we apply them, or we analyze them in the context of the rule of law. And here is where the various elements will come in. And the C is the capacity, the power to use, or the conclusion. I'm sorry, C is for conclusion. What is it that the decision will ultimately be? So IRAC. We have the issue, the rule of law, the application, and then the conclusion. let me just uh, say this right now, and then you can probably pause this and kind of like take it in a little bit. IRAC, in the context of law. So we've all heard an old nursery rhyme. Jack and Jill went up the hill to fetch a pail of water. Now, what if instead at the top of the hill, Jack says to Jill, Jill, I brought the pail up here many times. Now it's your turn to carry it down. And Jill refuses. Jack says, wait, that's not fair. I've always taken the pail up and brought it down. And now it's about time that you do your share and you bring it down. And Jill refuses. Jack then says, look, if you don't take the pail back down, I will use it to hit you in the head. Jill still refuses. Jack proceeds then to hit Jill in the head with the pail. Has Jack broken a law? All right, so now remember, law, these rules or regulations that tell us as a society what we should or should not be doing. So one would think that there must be some kind of law that says that you can't hit people on the head with a pail, even if they didn't do their share of the work, and they've been getting a free ride for all of these centuries that this story has been told. So did Jack break the law? So let's take a look at it in the context of the three elements of law. The first is right. Does Jill have a right not to be hit in the head with a pail? And let's say that this is more than just a light tap. This is not being funny. A cut opens on Jill's head. There's a contusion and blood starts to flow. Does Jill have a right to have her person protected and not violated by Jack hitting her or anyone hitting her on the head with a pail? Second, the duty, the special obligation. Does society recognize an obligation that Jack should not do this or no one should do this to Jill? So is there a special obligation which is recognized as being owed to Jill? And then finally, the capacity. Does Jill have the capacity or the power to use the legal system to enforce her right to be left alone? As we go through the idea of IRAC, the issue is, did Jack break the law? The rule of law is law itself, that which is to be done or not to be done, and has three elements: the right, the duty, and the capacity. The application or the analysis is looking to see whether or not all three elements were there. Right, and we have established that it has. Duty, we also established that that has. And capacity, we do know that Jill has the power to use the legal system to enforce the right. Now, in this case, this is getting a little bit ahead of myself, but we know that there is both a criminal action and a civil action. The criminal action is, of course, the assault and battery, causing the harm of another person without justification or provocation. The civil aspect of it is the money damages. Will Jill be deprived of certain economic advantages or opportunities because of the injury that Jack committed to her? So we're going to be looking at whether or not Jill can get money, like, have you been injured in an accident? If so, then you might have the opportunity to use the legal system to enforce your right to get back money for doctor expenses, hospital expenses, attorney expenses if you have to go to court, lost wages, future damages perhaps, some kind of trauma or PTSD that may have been created. So this is the way that we'll look at this as far as analyzing the law is concerned. So with that, I'm going to take a little break right now, and you can kind of like take a look at your notes and think about this. Okay, so that probably didn't do much as far as the break is concerned, because all I did was pause the recording so that you could stop it and start it again. And here I am again, still sitting up here in the park. Looks like some clouds are coming by. But One of the other things that we need to discuss at this point is the Constitution of the United States. The Constitution is said to be three things as well. One is the supreme law. It is the law of the land. In respect to the Constitution, no other law can rise above the Constitution. In other words, if any law tries to supersede or negate the Constitution, it will be deemed to be unconstitutional and it will fail. This is going to be important in business because we know that there are sets of laws that are imposed by the federal government, and the federal government derives its authority from the Constitution of the United States. Now, at times you might find in business that we have both sets of rules operating, both the federal Constitution as well as the state Constitution. So you will be required to understand that in many aspects of doing business, you must follow at least two separate sets of rules, one being the state rules and another being the federal rules. If we were to look at, let's say, food service as an example, if you sell food that's made to be put into interstate commerce or commerce across the state lines, then you must comply with certain labeling requirements. And if you buy something and you see that information placard that has nutritional information, that is there because of a federal law. Now, at the same time, wherever you are producing the food that is going to be packaged and sold, you must normally meet with state health and sanitation standards as well. So when you go out to a restaurant and you see that green or red sign, hopefully it's green, you know that they passed the state regulations and they are certified to serve food. So the idea, though, is that you have both systems operating simultaneously, which causes a greater amount of regulation and having to know a lot more about law than maybe you ever really wanted to. So the first thing about the Constitution, and I said there were three, is the supreme law. The second, it is a brake on the power of government. A brake on the power of government. It's like braking a car, before it gets to going too fast and becomes dangerous. The government has huge power. Think about the kind of things that the government can do under the powers that it has been granted. The government can arrest you. They can take away your money. They can seize your bank accounts or levy assets that you may have. All of this will be used against you in the event that the government finds that you did something wrong. But the idea, though, is to not allow the government to have unrestrained power to do that to anyone it wants whenever it so chooses. So the idea is that the Constitution is a brake which limits the power of government. You're probably familiar with the most famous due process brake on the power of government that exists. And this is from the realm of criminal law, so forgive me. But in criminal law, you all know by heart, you have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to have an attorney present during questioning. And if you cannot afford one, one will be appointed for you. Are you aware or do you understand these rights? Now we see this, we hear this all the time on those Cops and Roberts show. We know that that's the Miranda ruling, the Miranda warning, and that is necessary to be given to apprise suspects of their rights so that they do not incriminate themselves, the Fifth Amendment, and that they have a right to a fair and speedy trial by a jury of their peers, their Sixth Amendment. Now this is very critical in the realm of criminal law, because in criminal law, you can go to jail, and in some instances, you could actually be put to death. Now, Hawaii does not have the death penalty, but the death penalty can be applied to crimes which do occur in Hawaii if those crimes occur on a government establishment or government property, or they are directed towards a government employee. In these instances, the death penalty is available and can and has been used in the past. But as of 1976, Hawaii has no death penalty as far as violations of state law are concerned. So the first two things, the Constitution is the supreme law, and it is a brake on the power of government. Now, beyond that, the Constitution is also what we would say today to be Supreme Court interpreted law. Now remember, the legislature makes the law, but the Supreme Court interprets it. So who interprets the supreme law? It is the Supreme Court. And this is something that becomes very, very critical to recognize because it does have tremendous impacts on business. Because remember, the Constitution does have the power to regulate business as well. And those on the Supreme Court have the power to interpret what those, or the extent of those regulations and how much they can affect business. So think about it. I mean, many of you have probably seen RBG, the notorious Ruth Bader Ginsburg. She is a liberal justice. She is one that looks for the rights of the little people, I would say. Now, Republicans, on the other hand, or conservatives, are very pro-management. I don't say pro-business, I say pro-management because they very much look towards not allowing regulation to be imposed upon businesses in general. And that really is something which frees management from a lot of responsibilities. And we'll talk about that a little bit later when we talk about ethics, and I'll go do that inside somewhere so that you can actually see different things in a different way. But for now, understand that the Supreme Court interprets the Constitution, and the makeup of the Supreme Court can greatly determine which way businesses are regulated or less regulated in the future as laws become contested and go before the Supreme Court for adjudication. Now, after the idea of the Constitution, we know that we have to deal with property rights or property law. There are two basic kinds of property that we look at, one being physical and the other being in the context of goods or tangible, movable items of personal property. So goods like a wagon, like I see the guy rolling across the street right now, or cars like I see parked in front of me or roll again coming down the hill. They are also things of the nature of some of the things that are around me. Like some of these plants are probably items of personal property because they're small. They look like they could be easily dug up without causing much damage or change to the land itself. Let's say, for example, here, this pot that has a little plant in it, or well, maybe not so little, but that's meant to be moved around, right? As are these. They're meant to be moved. So in the event that somebody were to, let's say, sell this land or give this land away, they could take these little plants with them because they were meant to be moved. Now, on the other hand, if we look at this paper tree right here, as I turn it so you can see, it's very nice sitting out here. Or perhaps the, what is that, a monkey pod tree back there? Or the palm tree directly in front of me. These trees are fixtures. They're part and parcel of the land. They're really not meant to be moved up. So this is something that you would not expect to be moved in the event that somebody sold you this land. Now the land itself, as well as these big trees, are what we call real property. Real property is the ground or the land. Buildings, like this is Berkshire Hall right here that you see in the picture. This is essentially called real property. And real property is that which is immovable. It's meant to be part and parcel of the land itself. And if you were to buy the land, you would expect the building to be there, and the law would say yes. Now, other things we'll find out, and shortly as we talk about contracts, we know that things that are in a contract, when you come back, you expect certain things to be there. So if you buy the land, you will get the building as well, unless other arrangements are made. But if you make no arrangements, if you do not specifically say, hey, I'm selling you the land but not the building, then you do not get the building. Now, we know this the case to be the way that things go with leases, so that you lease or you rent the right to use the real property, like the building or the apartment or the condo, for a fixed period of time. And after that period, you must return the entire property to the landlord or the legal owner of that property. And when we talk about contracts, we're going to see why it's very critical to understand that you get to make the rules, you get to set the terms and conditions, and as a result, you should be very careful and thoughtful about those things. Now, beyond that, we also have intellectual property. Intellectual property, IP, something that you cannot get away from as far as business is concerned, unless you're like me and are going to retire shortly. You will have to deal with the realities of intellectual property, whether they be patents, copyrights, trademarks, or other items of property, which perhaps we're not even familiar with at this point in time, but they become intellectual property. These items of property are what are known as intangible property. Land and goods are tangible. You can see them, you can feel them, you can touch them. Intangible property, on the other hand, is property for which there is no real physical substance, but something that represents the right to something else, as in a copyright. There is a right that the author of the work maintains so that they can have it used as they see fit, or they can charge for it, or they can do something, give it away, whatever it might be. And this is something that we all have to deal with. So we will be dealing with intellectual property for a long, long time to come. Now, beyond that, there's something that's known as international law, to which I will suggest that there is no such thing. International law, or the way that nations interact with each other from the perspective of right, duty, and capacity, is severely lacking in the final element of capacity, because there is no one body that rules supreme over every nation on the planet. Now, there are things called the World Court or the International Court of Justice, but for the most part, those courts derive their capacity or their power only because the parties who are subject to cases before them are willing to be subjected to the results. They are willing to accept the determinations of these bodies. They do not have to, unlike in national law, where if you are doing something for which the law has said there is a prohibition against it, you cannot say, well, I don't think that's right, so I'm not going to follow it, and then get arrested for it and not have to go to jail or not have to go to court or not have to pay a penalty for your non-belief in the law itself. Contrast that to things which happen internationally, which really mean that the nations will only be willing to accept the results if they have voluntarily come to that conclusion or that agreement. Think about one of the biggest issues confronting us as a society at this time, global warming, climate change, whatever you want to call it. The Paris Accord, basically the Paris Climate Accord was one in which several nations got together and said that they were going to reduce the amount of greenhouse gases being produced in their countries. And they were all going to come together and voluntarily do this. As you recall, the United States has recently said, we don't believe in this anymore, so we're not going to follow it. Now, if this were truly law, then the United States would have no choice but to follow the rule of the Paris Climate Accord. But we know that because it is an international agreement in the nature of a treaty or a contract or an agreement, that the U.S. is not bound to it under all circumstances. All right, so I'm going to push pause again, and we'll see what happens. Okay, so I guess I should turn this around again for a little while, so you know it's still me, and you know who to run and hide from when you see this person on campus, especially if it's around a classroom and I'm carrying a stack of papers. They're most likely exams, but hopefully that doesn't make anybody nervous. So the next subject is tort law. As far as tort law is concerned, tort law is law which is the personal right. Torts protect people from injury, and they protect people from injury against their person their property. This towel is a piece of property. This thing in front of you is a person, or their reputation. I do have a reputation which I strive to continually perfect, which basically is one that says I don't like technology. So, person, property, or reputation. Now, of course, we know when a person is harmed. Have you been injured in an accident? They're asking you if you've had suffered some kind of physical harm, or have you gotten something taken from you? Has your car been smashed? Has your property been damaged? And then finally, has somebody said something about you which was untrue and they had no right to say? It goes beyond merely stating opinion, and it has the nature or the result of causing you a harm to your reputation. This happens in business a lot. That's why people really don't like, or in many countries, you still can't do comparative or comparison advertising, because one is going to be deriding the property or the reputation of the property of another. When someone says that the other product is inferior, in fact, if it is not in fact inferior, if that's just a matter of opinion or puffery or sales hype, then reputational damage has occurred in the business context, and that could cause for a fine or other kinds of relief measures, such as cease and desist orders. So those kinds of advertising can no longer go on. And then this is something that you will have to deal with as far as business is concerned. But torts can be committed, harm can be committed on three things: the person, the property, and the reputation. Torts are committed in one of three basic fashions. One is intentional. That means you intended to do something which causes the harm. You don't have to intend to harm a particular person or thing. The mere fact that you voluntarily entered into some kind of event, or you put into motion something which caused another harm, even if it was not the person you were aiming at, means that you have intentionally harmed another. This is the idea of intentional tort. So if you throw a rock at your friend, but you hit people on the other side, you're still committing an intentional tort because you intended to throw the rock. It is not that you intended to hit a particular person, right? Who you hit basically will determine who gets to sue you, but they're going to sue you for an intentional tort. The other way that torts can occur is through negligence. Negligence is when we look at foreseeability or the likely outcome of something, and then whether or not we have any responsibility to prevent that outcome from occurring. So the typical tort in business would be a slip and fall. This is the idea that business was negligent in allowing for a situation to exist which caused the individual who is harmed to fall down. You go to the produce aisle and there's a grape on the ground. Somebody steps on it, slips, falls, injures themselves. This is negligence. Negligence has four unique elements. It has a right not to be harmed, a breach of that right, or a duty. I'm sorry. First is a duty not to harm anyone. So you have a duty, and then someone breaches that duty. In other words, they don't honor, respect it, or prevent something from happening. The third thing is injury. Somebody has to get hurt in one of these things. And then causation. The idea of but for or because of the failure to comply with the duty, the injury occurred. So it connects the duty with the injury and imposes the responsibility upon the business to make sure that, or the individual to make sure that the injury does not occur. Right? So duty, breach, injury, and causation. These are the things that basically constitute the tort of negligence. And negligence will be one of the most commonly experienced torts by everyone, personally and in the area of business. And then finally, we have a tort area called strict liability. Strict liability is liability without fault. Liability without fault means that the thing that you did, or the thing that you were doing, or the thing that you had was so abnormally dangerous that there was no way that you could possibly um, do the things that were necessary to prevent harm in all situations. Classic example, pit bulls. My little dog here goes after pit bulls because he's not too smart. He's got a Napoleon complex, I believe. But anyway, a pit bull is deemed to be, in many instances, an abnormally dangerous animal. Now, I know that's not true, but it is the perception of society. So that if a pit bull were to attack a child, the owner of the pit bull would automatically be liable for the child's injuries, regardless of what the child may have been doing or the things that the child may have actually done to provoke the dog to get into it with the child. Because pit bulls are deemed by society to be abnormally dangerous animals, then automatic liability is applied to any owner of a pit bull whose animal creates harm in any circumstance. Yes, it's not fair, but remember, we're not talking about fair, we're talking about the law. We're talking about what's legal in this instance and when you get sued and how you get sued. Another thing that could happen in business, of course, is an unsafe product that is manufactured without all due diligence being put into the manufacturing progress. So if the product was not supposed to cause harm and yet it does, so let's say you manufacture some kind of aerosol spray product and the can explodes in somebody's hands. Now, under normal circumstances, that's not supposed to happen. And strict liability would be imposed upon the manufacturer so that the manufacturer would have to pay for the damages, even if this was something that they never thought about or never saw in the design process. So understand strict liability, liability without fault, and understand whatever area of business you might be getting into that might be subject to strict liability. The other things that I do want to talk about before closing this section are agency law, also related to employment law or employee-employer relationships. An agency is a two-party relationship. An agency is a two-party relationship in which one party, who we call the agent, functions for the benefit of and under the direction and control of the other party, who is called the principal. So the agent functions for the benefit of and under the direction and control of the principal. In many respects, this resembles the relationship between employer and employee. The employer is responsible for the employee's actions because the employer has control. The employee is functioning for the benefit of and under the direction and control of the employer. So the employer is expected to impose reasonable supervision and make sure, to the extent possible, that things do not go wrong in the situation. The other way of looking at agency law or employer-employee law is Joe Aloha drives the bus. Unfortunately, Joe Aloha runs over Mrs. I'm going to sue you, causing her harm. The first thing that Mrs. I'm going to sue you is going to do, if she survives being hit by the bus, is jump up and look at Joe and say, I'm going to sue you. And she's suing Joe for negligence. Joe, as the bus driver individually, had a duty not to run Mrs. I'm going to sue you over. He breached that duty when he hit her. She was injured. When you get hit by a bus, normally you get injured. And Joe's breach of his duty was the cause of Mrs. I'm going to sue you's injury. So clearly Joe is liable for negligence because he's the one controlling the bus. Now, beyond that, though, Mrs. I'm going to sue you is going to see the logo on the side of the bus and say, hey, I'm going to sue the bus as well. Why? Well, we know the easiest response to that is because the bus has deep pockets. The bus has more money than Joe. And Mrs. I'm going to sue you has a better and a more probable likelihood of recovering damages from the bus than she does from Joe Aloha, the individual. The other thing, of course, is the bus, the company, is the entity that put Joe in charge or put Joe behind the wheel of that bus. The idea being that they should have given Joe adequate supervision, or they should have adequate control over Joe so he doesn't go running people over. So this is the idea that the employer or the principal has a responsibility to third parties to ensure their safety, because they're the ones that put the person into the situation where the harm occurs. Same thing, we hear about negligent hiring and negligent supervision a lot. If you think about Chaminade, there's a Montessori preschool. My daughter went there many years ago. They hire people to teach. They also have student teachers there as part of the educational process. Now, what would have happened in the event that one of these people were a child molester and they had in fact then molested my child, my daughter? I would not stand for that, and I would be suing the school for whatever would be necessary to try to make my daughter's situation whole. The idea being that, of course, that the school should have run the background checks. They should have done those kinds of things to see whether or not this person was, in fact, one with a predilection for child molestation. So if you improperly hire, improperly recruit, improperly manage your employees, you can find yourself responsible for their actions in tort. Also, if they go out and they sign a contract on your behalf, you may be required to make good on that contract, even though you may not even have known about it. So Joe driving the bus way out in the countryside, running out of gas, not close to any place where buses normally get their gas tanks filled up by the bus, goes into a service station to fill gas. It costs a lot of money to fill up the tank of a bus. So Joe is going to be out of pocket a lot of money. Joe says, I don't have money, but can I just sign for this on the bus's account? Now, if Joe does that, he's doing that for the benefit of the bus, not for himself. He's not going to take the bus home and drive it around for personal purposes. He is going to be, saying to the bus company that, look, I'm doing this for you. And the bus company, therefore, will be liable for paying the contract for the gas. So this is when a third party can become a party to a contract with someone that they didn't even meet, or wasn't even there, or did not sign the contract personally. So Joe's action as the employee or the agent of the bus will be something which brings liability to the bus, the principal, for contracts that were entered on behalf of the bus, the principal. Okay? Now, beyond that, beyond agency, then we know that there is a choice of entity. As far as choice of entity is concerned, we have a situation where you can do business in a legal form. They all derive from three principal forms. One is a proprietorship, the second is a partnership, and the third is a corporation. These are the three principal forms of doing business. What we see here is that you make a choice. You do it by yourself, and if you don't think about anything else, you're automatically a proprietor. You do it with someone else, and you become a partnership. Or you think through the situation, and perhaps you form a corporation or an LLC or an LLP or something like that. But you have to think through the situation. You have to understand what is required. And then you can have the legal protections, principally limited liability from the very beginning. Understand if you fail to do this, you will not be granted limited liability, and you could lose everything that you own, even those things which were never meant to be used for the benefit of the business. So with this, I'll stop this part of the recording and get back to you and talk about something else, because I'm getting rained on right now. Thank you.